Today's tip comes from The Way of the Trial Lawyer Beyond Technique by Rck Friedman. Here to read it is Rck Friedman. Thanks for being here this morning, Rick.
Thank you, Michael. Jurors, and often judges, usually do what they feel is right and fair, not what they think is right and fair. Being able to tune in to what is going on with other people requires practice, at least for most of us trained as lawyers. That is where much of the action is. Over time, we become more skillful with the language of feelings, and we become more persuasive.
So, feeling versus thinking. I know that's been a huge journey for me. Someone who's in my head a lot and has had to learn to feel. I think that is true for a lot of lawyers, for a lot of people. Can you speak to that for us?
Well, a lot of people, but in particular, a lot of lawyers. I mean, I think people who get into their heads tend to gravitate to law school, and then law school kind of tries its best to squash any feelings out of us and say they're irrelevant. But we know from social science, if nothing else, there's plenty else, but social science has now taught us even the most technocratic judge is influenced by their feelings, and even whether they know it or not. And so, so a large part of what this book is about is trying to get at the things that are not pure thinking that influence the results in trial. And there are lots of those things, but feelings is a big part of it.
And I mean, it's true with judges. We don't think of it there, but it's certainly true. And it's certainly true with jurors, right?
Absolutely.
Yeah.
Yeah.
Wow.
Yeah. And I mean, feelings have gotten a bad name, both with jurors, judges, and lawyers, because it's thought of as manipulative. I'm going to cry in front of the jury to make them want to give my client money, or I'll make my client cry in front of the jury to make the jurors want to give more money. But that's not what this is talking about. This is talking about what are the legitimate human feelings that arise when you hear, I don't know, a kid has been injured and is going to be in a wheelchair the rest of her life. There are natural human feelings that are triggered by that. You don't have to play to them so much as be aware of them. I mean, it's a complicated subject and it's hard to talk about, but that's what I'm trying to get at here.
Yeah, I think it's very wise to talk about to bring the feelings, but you don't have to bring them in a way that is manipulative. You should never do that to like, oh, look at my poor client, but rather you can factually represent, here's a young girl who's going to be in a wheelchair the rest of her life, and have room for the feelings that will bring, right?
Well, yeah, and be aware of your own feelings. I mean, if I change the hypothetical for a minute, let's say you've got a case where your client has been injured and is comatose, and she's going to be likely comatose the rest of her life, and it's going to cost, $10,000 a month to keep her alive at home and $5,000 a month to keep her alive at an assisted living center. I think a natural human feeling, not judging whether it's right or wrong, is that's a waste of money. Why are we spending $10,000 a month to keep a comatose person alive? And so getting in touch with your own feelings about these kinds of things, about the issues in your case, I think is the first step. And you can't connect with other people and the feelings they might have until you connect with your own feelings.
So in that example, I know how I deal with it, and that would be just to say it to the jury. Like, I wonder, is it a waste of money? Should we only give the 5,000? That's the only way I know how to deal with it, but are there other ways, or how do you deal with it?
Well, I mean, that one particularly troubled me. I had a case like that early in my career, and it was, I found it very disturbing. And the answer, well, so part of the answer is what you said. Part of the answer for me is what you said, just putting it out in the open. And I had all kinds of various arguments about why it was worth it. But the one I liked the best, in fact, I think it might be in this book, I can't remember, uh, was given to me by Bruce Brulette. I saw he's a really good trial lawyer in California, and I saw a closing argument he did, and it had to do with, um, as much as we like to receive love, it's important to us as humans to give love. And the mom wants her child, her adult child, in her home, even though she's comatose, so she can give her love. And who are we to say she's not entitled to do that? I mean, the argument's longer than that, but that's the basic point.
Wow. And that's really a great example of being in touch with feelings and your feelings and the client's feelings and just some not common sense, but just human feelings. Yeah.
Yeah. And I, if I have just a minute, Michael, I mean, part of the difficulty of our jobs, I think, is we see so much carnage, and it's a human reaction to try to like shut the feelings down around it because it takes its toll, but that limits us as advocates. So I think what I'm trying to get at here and in the book is we open ourselves to this and have the courage and, I don't know, just the patience to hold these uncomfortable feelings, it'll make us better advocates.
Today's tip comes from the video Stop Your Whining and Go to Trial by Rck Friedman and Don Bauermeister. Here to read the tip is Rck Friedman.
All right. Spend time with witnesses and form relationships. Tell the witness how they fit into the case and ask open-ended questions.
This is great advice. You're saying to tell the witness how they fit into the case. Are you talking about doing that in front of the jury?
No. I'm talking about before, when you're spending your time with your witness, getting them prepared. I think a lot of us forget that for a witness, most witnesses, other than expert witnesses, this is a very disconcerting experience to have to go to court and take an oath and testify in front of people, talk in public. And, for most of them, the only experience they've had with court is what they see on TV or in movies. And so they get the impression one wrong word and the whole case will come tumbling down. They think they may have to, if we take, for example, a witness who maybe is just a lay witness who's going to talk about changes in your client from before versus after the accident. They don't know. They may be asked, how did the accident happen? They don't know any of that stuff. So it really calms them down, in my experience, to talk to them about, you're just here as an expert in how this plaintiff was during the bowling league on Saturday. And that's how you fit in. You're just helping the jury understand what impact this had on his life in the bowling league, not even in his marriage or with his kids or anything else. So it's very reassuring to jurors to understand their role in the case. So that's the basic point here.
That makes a lot of sense. I was thinking of something even beyond that. I wonder what your thoughts are when actually introducing, after you've told Joe that you're just going to be talking about Mark and how he used to bowl and how much he enjoyed it. Right. To actually say, and for our next witness is Joe, who's going to talk about Mark's bowling.
Absolutely. Yeah, absolutely. Different judges have different reactions to how much editorializing you can do, as you know, but yeah, absolutely. Honestly, I've never done that, but I like the idea.
Today's tip comes from the classic Rules of the Road, A Plaintiff's Lawyer's Guide to Proving Liability by Rck Friedman and Patrick Malone. Here to read the tip today is Rck Friedman.
When you reach the point in the deposition where it is time to talk about the rules. Begin with the 2 or 3 rules you believe are the least controversial and supported by the most authority. Don't start with the rule, but with the authority.
So, Rules of the Road, this guide, and if people listening don't have this book, go out and get it immediately, where you've made it accessible for lawyers to prove the standards, to show what the rules are. And you're saying, start with the authority for the rule. What do you mean by that?
Well, I don't know. I'll just use let's say a drowning in a hotel swimming pool. There may be, so the rule might be, you should always have a life preserver on the side of the wall within easy reach. I'm just making this up, obviously, but I've never done a swimming pool drowning case. But that rule, the rule, you should have a life preserver within easy access to the pool. There's probably authority for it. What's the authority? It might be a local public health, like a city ordinance. It might be Hilton Hotels manual. Could be, anything. Whatever that authority is, what I'm suggesting here is you start with that authority. You're familiar with the city ordinance, and those city ordinances apply to this hotel. So you set the foundation, or you're familiar with the Hilton Hotel manual on swimming pools. That's intended to govern how you run this swimming pool, isn't it? So you start with that authority, and then you would move on to the rule. You would agree that one of the things it says in this ordinance or handbook is that there should be a life preserver within easy access, wouldn't you? And that's a sensible rule, isn't it? And why is that? So earlier in the quote, it talks about, starting with the ones that are most authoritative, that the person's least likely to fight, because if what you're doing in part is educating them that the subject area, you're familiar with the authorities, and you're not going to be wasting time or asking about things you don't know about. So once they've agreed with the first few authorities and the first few rules, it becomes easier and easier to get them to agree to maybe the ones that are more controversial. So that's the point of this.
Yeah, it's very helpful. And I love your example, because you're saying, first of all, statute 123.72 says have a life preserver in easy reach. And then the second part of it is, you said, make sure it makes common sense. And of course yours does, because you took it out of your mind. You don't handle swimming pool cases, right? But you try to think of what's something that's so common sensible. And that's what we want to do in our cases, something that the jury would say, of course, that makes sense.
And usually in any case, there are things like that that are kind of common. I'm sure in trucking, what would be an equivalent in a trucking case? There must be something like that everybody sort of recognizes that comes up in most cases.
When there's bad weather that affects your visibility or traction, slow down, increase your distance.
Go. Yeah. Perfect.
Go ahead and argue with that one. I want you to. There's some big verdicts with people with truck companies that have argued with that.
I bet. Yeah. Great. Yeah. That's perfect.
Today's tip comes from the video Stop Your Whining and Go to Trial by Rck Friedman and Don Bauermeister. Here to read today's tip is Rck Friedman.
Thanks, Michael. This is a short one. Don't take a weak case thinking you can settle it.
So it's short, and I think there's a lot there. Don't take a weak case thinking you can settle it. Tell us more.
Well, the weaker your case, the more likely the defense is going to want to fight it to the end. That's just common sense when you really think about it. And I see so many plaintiff lawyers kind of overlooking the weakness in their case, the fatal flaw, whatever, because they think, well, the defendant will want to get rid of me. They'll pay us something, so I'll just take it. And then and I've done this myself, I see so many lawyers having taken that weak case, it becomes like a tar baby. You can't get rid of it. And it just bedevils you until it's over, and it almost never turns out well. So if you know it's a weak case, if you're not, well, and I've taken weak cases knowing I'm going to try them, that's fine. But because sometimes a weak case needs to have somebody advocate for it. So I'm not saying don't take a weak case, but if you're taking a weak case, be prepared to go the distance because the defense will probably be eager to go the distance.
I remember hearing at the beginning of my career, it's saying it was something like, if you take a case and try to settle it, you'll end up at trial. If you take a case and work it up for trial, it'll end up settling. I think
That's brilliant. I've never heard that before. That's a great saying.
Yeah, and as plaintiffs' lawyers, we get to choose what cases we take. So I think what you're saying is, if you want to help someone and there's problems, just be willing to go the distance, right?
Absolutely. Absolutely.
Today's tip comes from The Way of the Trial Lawyer, Beyond Technique by Rck Friedman. And here to read it is Rck Friedman.
Thank you. To begin with, self-righteousness can lead to black and white, all or nothing thinking. To be the strongest possible advocate, we must understand and appreciate the good in our opponent and the strengths in their positions. To enter a legal fight blind to our opponent's qualities is to enter, well, partially blind. It will lead to defensiveness and misperception. It virtually guarantees impaired advocacy.
You've packed so much into these few sentences. You're talking about the danger of self-righteousness. You're also talking about not underestimating your opponent. Can you talk more about that?
Well, in my experience or observation, those tend to go together. You know, it's fine. It's important to believe in the righteousness of our case. You know, as plaintiff lawyers, we get to choose our cases, and hopefully, we choose cases we believe in. But if all you can see is the rightness of your cause, the rightness of your case, you've got some blind spots because there's almost always some merit in the defense case, and sometimes a lot of merit in the defense case. And if you can't see that because you're so in love with the righteousness of your case, then you may not see those blind spots coming at you. What's in those blind spots coming at you. So that's the basic idea. You know, if we're holding on so hard to our beliefs about our case, and I'm sure you've seen this too, Michael, either in yourself or in other people or both. We all fall prey to this, but yeah. So this is a reminder to myself as well as to everybody else.
Absolutely. How do you do that to see the merit in the other side's case? I mean, is it through working up the defense focus group, or how do you personally do that?
Why listen? You know, one of the key qualities of a good trial lawyer is the ability to listen to people and listen to things you may not agree with. So that's that's a trait or a quality you can develop in yourself. And so when I read their briefs, and we've all had that experience, you know, the defense brief comes in and you have that sickening feeling like, oh my God, my case is lost. And then you start working on your brief and you research the cases and you start feeling better usually. But that moment, that sickening feeling, oh my God, my case is lost, when I read their brief or I hear their oral argument or their opening statement, or in deposition, I hear their questions of our witnesses. You know, instead, it's uncomfortable. And I think that's partly what happens is it's uncomfortable to hold two ideas in your head or in your heart at the same time. Much easier to just push aside. Like, I don't want to think about climate change, so I'm just going to pretend it doesn't exist. It's the same kind of thing that we do when we work on our cases. So in answer to your question, I try to listen to what they're saying in their brief, what they're saying in the depositions, and really hold it and turn it over in my mind and think about the implications and how it might land on somebody who's never heard about this case before.
Today's tip comes from The Elements of Trial by Rck Friedman and Bill Cummings. Here to read today's tip is Rck Friedman. Good morning, Rick.
Morning, Michael. Many trial lawyers refer to a trial as a battle for credibility or a race for credibility. They recognize an indisputable truth. The lawyer with greater credibility with the jury has a huge advantage. You don't begin a trial with credibility. You have to earn it.
Wow, that seems especially true for the plaintiff's bar, right? We have to earn it.
Yeah, absolutely. Yeah.
Yeah. This is a theme that I would say is really the most important thing. I can't think of anything more important in trial. I mean, the truth, credibility, those are the two things that come to my mind.
Yeah, absolutely. And it's I think it's not a well understood concept, really. Well, I don't know. I maybe it's understood, but I get the sense that most lawyers think they can force credibility. It's like forcing someone to respect you. You cannot force it. You cannot force someone to view you as credible. You have to do it. You have to actually act in a credible way. There's no other way to get credibility.
So specifically, how do you do that? You do this very well. Like, is there some mindset, I think there's some courage, but I'm curious where it comes from in you.
Yeah, there's a lot of, in me, that would take a long time to talk about, but I think uh, the it comes from, I guess a good starting point for most of us would be you have to want to level with the jury. You have to want to be transparent. The other things that are commonly talked about is you got to be prepared. If you're not prepared, you're not going to have credibility. You need to be competent. But that's a funny thing. Like the first time lawyer can be credible even without being, quote, competent, maybe like you and me would be. They may not know the rules of evidence as well and so on. They can still have just or almost as much credibility just by being honest about, what they know and don't know. And yeah, so I think it's shedding your desire to look a certain way or to have your case look a certain way and be willing to just be a dealer of, that's not the right phrase, a merchant of the truth, a merchant of transparency. And that's hard. It's easier said than done, as you know. But how do you do it?
I'm the one asking the questions here. No, that's something I never say in trial. If people want to ask me questions, it seems only fair they should be able to.
Yeah.
I think it's really being in touch with my feelings and being willing to share them with the jury, especially those that maybe go against my case, or that sound like they do. So that might be the credibility might be, you might wonder, what good will this money do when this person's already been killed?
Yeah.
All you're doing is, if you have questions in your mind or doubts, then other people do too. So the credibility comes with just owning it, I think.
Yeah.
Today's tip comes from Polarizing the Case, Exposing and Defeating the Malingering Myth by Rck Friedman. Here to read the tip is Rck Friedman. Good morning, Rick.
Morning, Michael. Thank you. Closing argument is the time you get to hold the defense accountable for its attacks on the plaintiff. What they've done is despicable. It's time to point that out.
So what the defense has done is despicable. You point that out. You're not someone, frankly, I'm not either, that's known for screaming and yelling in front of the jury. So,
Yeah.
So how do you do this?
Well, as the quote came up, I was thinking about how important timing and tone is, and how, every case is different. There's no formula for this, but often it's only as the trial has progressed that it becomes clear to everybody what the defense theme is. Your client's a liar, a cheat, and a fraud. And so, yeah, it's in close. I tend to hold back, not always, but most of the time, hold back on really pointing out how despicable it is till closing. And then, yeah, and then it can be very straightforward and matter of fact and doesn't have to be histrionic. It can just be, over the last 2 weeks, we've seen what the defense is. The defense is that Mrs. Smith is a liar, a cheat, and a fraud. And if that's true, you should send her out of here with nothing because she doesn't deserve it and she should be ashamed of herself. But if she's telling the truth, and then I might list some of the evidence that she's telling the truth, what the defense has done is despicable and they should be ashamed of themselves. And she's entitled to a fair award based on the evidence. And here's what the evidence shows. So that's the shorthand version of what I'm talking about.
Yeah, it's brilliant because it's to the point. It's matter of fact. You can't really argue with it. You're revealing yourself, saying if that's the case, it's not what the jury expects you to say, then send her home with nothing.
Right.
And there's something else in it, which is the way you say it. And I think every trial lawyer has to find their own voice, but the way you say it, you're not taking the anger from the jury. You're
right.
angry, but you're not so angry that they don't have space to say, what do you mean, son? Let them get angry.
Well, yeah, I mean, that's the whole induced emotion thing, right? If you are having all the emotion, there's no room for the jury to have emotion. So, yeah, I think you got to show you care by the time of closing, at least. You have to show you care and you have to show what you think of it. But, it can be pretty subtle. Doesn't have to be table pounding and screaming to get the point across.
Today's Trial Guides tip of the day comes from The Elements of Trial by Rck Friedman and Bill Cummings. Here to read that tip is Rck Friedman.
Thank you, Michael. Ask questions of the court personnel and judges, as well as other lawyers who have practiced before them. This is what experienced lawyers do. Inexperienced lawyers sit quietly, hoping no one will notice how little they know.
So ask questions of the court personnel and judges. For example.
Oh, like, how do you like to do voir dire? How many, do you let the jurors take notes? Anything you don't know that you're wondering about, ask on the record or off. It doesn't really matter. Yeah.
I love that you've included court personnel in this because so often whether it's the judge's bailiff or even the court's court reporter, to say, hey, what can I do to make your job easier? Or just here's how you can get in touch with me.
How do you want exhibits marked? Would it be easier if I did this rather than that? Yeah. I mean, you ideally you want to become part of the team with the court reporter, the bailiff, and ideally the judge. We're going to work on this together to make it go smoothly. And I'm new in your courtroom, so I have lots of questions. Let me ask about this. Let me ask about that. They appreciate it.
It's great advice. Not only does it help you put on your case, it also is part of just being a decent human being, I think.
There's that too. Absolutely.
Which lawyers can be and often are decent human beings.
Yes, we can be if we want to be.
Today's tip comes from Polarizing the Case, Exposing and Defeating the Malingering Myth by Rck Friedman. Here to read the tip is Rck Friedman. Thanks for being here.
Thank you, Michael. What the IME doctor doesn't do is often more important than what he does. For example, doctor, you never asked her blank, did you? You say you doubt this part of her story. Did you ever talk to her boss to verify it? Did you ever ask for the boss's deposition?
So you're talking about a doctor that examines your client and says, I doubt that, I think she can still work, or I think she can still do her job. I'm trying to think of an example. And then you'd say, did you talk to her about her job?
Yes, exactly. And just as you put this up on the screen, I was thinking, defense lawyers are way better at this than plaintiff lawyers. And if you pay attention to what defense lawyers do, it's often, their business is tearing down people and tearing down cases. And, I just was in a series of depositions, doctor, you're not an epidemiologist. You're not a industrial hygienist. You're not this, you're not that, you're not the other thing. I wanted to say you're not an astronaut, but it's like so they do it all the time. They tend to be better at it than us. But for the IME doctor, that is a very good line of inquiry. You only spent a half hour with her, or you only spent 2 hours with her. Did you do this test? Did you do that test? Going into a deposition of an IME doctor, I'd make a list of everything the doctor didn't do that could appear relevant to a jury, and then just keep asking those questions, one right after the other after the other. It can have a profound effect. And it's a kind of cross-examination anybody can do. It doesn't take any particular skill, just the ability to sit down and make your list.
I love it. It gets to the logic of your case, and it also gets to really what's, I think, most important, the credibility of your case, and if the other side is credible. So I think the subtext of what you're saying is, if you really were trying to get to the truth and not just testify against this person no matter what, because that's what you're being paid for. If you're really trying to get to the truth, why wouldn't you ask?
Yes,
blah, blah, blah.
Perfect. Exactly. Yes.
Today's tip comes from Becoming a Trial Lawyer, a guide for the lifelong advocate by Rck Friedman. Here to read today's tip is Rck Friedman himself.
Thanks, Michael. To figure out if you have what it takes to be a trial lawyer, I suggest looking inward, not outward.
Wow, great advice. I think of, back to the Oracle at Delphi, know thyself, look inward. What does this mean for you? How can others take this on?
Well, I think, it means a lot of different things to me, but the thing that pops into my head first here is, I think a lot of trial lawyers, especially beginning trial lawyers, are focused on the externals. I'm not tall enough. I don't have a deep enough voice, or, whatever they think their shortcomings are. Or you run into people that think, oh, I'm tall and handsome and have a deep voice, and I must be a great trial lawyer. And, as good trial lawyers come in all shapes
are not tall and are not handsome, and sometimes wear a beard, I hope.
Yes, right. Yeah, they come in all sizes and shapes, and it's really not about those externals. It's about a lot of other things, which we could talk for days about. But in my mind, are you willing to fight for things you believe in? And are you willing to lose? Are you willing to have setbacks? And do you internally have the resilience to keep pushing back, keep doing things that are scary over and over and over again, and even failing over and over again, and keep going? And as you know, that's not everybody has that inside, and really the only way to find out is to experiment with it, I think.
So great trial lawyers are people who can be in the courtroom and be credible and know themselves. And what I hear about you a lot, when people will say Rck Friedman, the great trial lawyer, Rck Friedman, and all these successes, and what many times will follow that and will be something like, he's so unassuming He's just like a down-to-earth person. He doesn't seem to be boisterous and loud and so I hope you take that in as a great compliment.
Uh,
And I'm wondering
I do.
if you can just reaffirm that to those who are watching who feel like, no, yeah, I'm not a model. I'm not. It's something much more than that, isn't it?
Well, that's actually what this whole book is about that you have up on the screen. Uh, the introduction, I think I can't remember exactly, but somewhere right in the beginning of the introduction, I make the point, I'm not a natural trial lawyer. I was, and to some extent still am shy, uh, had terrible stage fright and on and on and on. So yeah, I think, each person has to develop their own style. Writers call it a voice, but, each writer has to develop their own voice or they're just a copycat and doesn't have much traction. Same thing, I think, with trial lawyers. Trial lawyers have to develop their own voice, and that there's room for all kinds of different voices in the courtroom, and you just have to find your own.
Some great wisdom this morning from Rck Friedman. Rick, thank you for being here today.
Thank you, Michael.